What I'm going to be doing right now in the chat is putting the link to the Google form for the roster. I couldn't think of what it was called. So make sure you copy and paste that link into your browser. Again, keeping your videos on, make sure if you have questions, unmute, or you can throw things in the chat. And keep in mind there will be 4 keywords given throughout class. So we'll try to be really specific on the keywords, make sure that you guys understand them. Those will be turned in on your roster. And yeah, so Scott is here and we'll get this kicked off. I'm going to start sharing screen and hopefully get him set up here. Okay, so y'all should be able to see that now. And I've got the chat open for him, so it is a good day for us here. I'm going to pop out a screen and let Scott hop in here and take it away. So, Scott, come on down.
Awesome. Thank you, Chantel. Good morning, everyone. My name is Scott Halverson. I am the owner here at Integrated Title. I've been in the title business 35 years and just excited to be with you guys this morning and hopefully give you some information. I know you're the experts on the contracts, not me necessarily, but I want to give you some information from the title perspective that can help you avoid any pitfalls or delays in your closing, because I know the last thing you guys want to do is negotiate settlement at deadline extensions. So hopefully we can cover some things that will help you and make it to where you shine in the eyes of your clients and get the repeat and referral business you need and deserve. So Chantel, thank you for the introduction and setting this up today. If you folks have any questions, I've never done this before, so I'm not exactly sure how long this will take on Zoom. But normally in a classroom setting with lots of questions and everything, it takes about 1.5 hours if we don't take any breaks or anything. So if it's okay with you folks, we'll just cruise right through this morning. And again, if you have any questions, please feel free to pop in at any time. Okay. Let's see, where's that little arrow Chantel was showing me? Which side? Here?
Yep.
That one. Okay.
There we go.
Nope.
Let's see. Might need to hover. Why is it not? There we go.
It goes. Okay. All right. First of all, and this is kind of small, so I apologize for that, but on the Zoom meetings and putting it on an electronic format like this, that's the best we could do. I'm going to get my C-close glasses out so I can see what I'm talking about. Okay. The first thing I wanted to mention to everybody is on the earnest money, the very first part of the document or the contract, it says that the buyer will deliver the earnest money to the buyer's brokerage. So, and that is really important to note because we'll get into that a little bit later, but just note that the REPC automatically states that the earnest money is to go to the buyer's brokerage. And it's funny, you talked about solar panels and getting a 1-hour CE class on that because that's the next thing I'm going to touch on. In section 1.1, something that's been added to the REPC just recently is solar panels to be included. So it's really, really important, you guys, when you go out on a listing appointment and, oh, Chantel's just pointing something out to me. So when you go out on a listing appointment, if you see that there's solar panels, communicate with your escrow officer as soon as you can, because that can cause some serious delays down the road, because if the seller owns it free and clear, it's not a problem. But if the seller has financed it, then we've got to figure out what we're going to do as far as, is the seller going to pay it off? Do they have enough money and equity to pay off the solar panel mortgage? Or let me rephrase, UCC that they record? Or will the buyer want to assume that obligation to the solar company? So that can happen either way. The way we prefer to do it is to have the seller pay it off, obviously. If the buyer's going to assume that, then we need to communicate that to the lender as soon as possible, because that's going to affect their debt to income. And so those solar panels are really important. If you go on a listing appointment and you see their solar panels, talk with your title company as soon as you can, so that when they do their search, they know that there are solar panels there and we can figure out how to deal with it early instead of late towards the end of the closing, or towards the settlement deadline, I should say. The other thing is that is one of our keywords today. Solar panels is our #1 keyword. Excuse me, I got a bit of a frog in my throat this morning. Okay, and then so that's really important. Like I said, you'll see it when you pull up for a listing appointment, or if you're showing a house to a buyer. Just communicate with your title company to make sure that gets handled. Okay, section 1.2. This is really important. In this world of split closings, we deal with every title company out there, and oftentimes they don't do a bill of sale for any of the personal property items that are on there. And the bill of sale is required under section 1.2 of the contract. It says the above checked items shall be conveyed to buyer under a separate bill of sale. So it's really important to make sure that we get those bill of sales done at the closing table and make sure that happens for your buyers. Okay, another thing that's changed is the water service. This can really be a delay if we don't deal with this up front as well. The new contract states now that it shall include all water rights or water shares, if any, that are the source for water. Really important to note, water rights will run with the property for the most part, but water shares are separate and can be withheld from the sale and sold separately, because the water share, you get a actual owner's certificate or a certificate of ownership from the water company for however much water you can use. So if you go out and somebody says there's water rights, or it's a good question to ask at your listing, are there any water rights or water shares that are included, or are there any water rights or water shares that you're going to want to exclude from the sale? Because if we don't ask that question, the contract automatically says that the seller will give that to the buyer. So really important to ask that question when you're at your listing, so that we don't have delays in the closing, finding out later, oh, there are water rights or water shares, and then we have to go back and research it. We have to do a water right quitclaim deed to file with the state, and we have to do a report of water right conveyance to file with the state. So water is another thing that we want to ask questions on sooner than later, so that we can address it and make sure you don't have any delays. Okay, and then you can specifically exclude any water rights or water shares from the sale. And that's why I say it's important to ask that question, because if they're going to exclude them, if the seller's, let's say the seller has 10 shares and he's willing to sell 5 with the property, but he wants to retain 5, then it would say retaining 5 shares, or however you wanted to word that in your contract. Okay, section 3.1, settlement shall take place no later than the settlement deadline. Again, that's why I like to make sure that we address any issues or concerns up front, so that we don't have any delays in that closing for the settlement. Okay, 3.2, this is important to note. Closing settlement has been completed. That means, and it used to be, we all called it closing, and we still do, most of us say we got to schedule a closing, but it's actually a settlement now, the way the new contract is worded. So it says closing means that the settlement has been completed. The proceeds of any new loan have been delivered by the lender to the seller or to the escrow closing office, and the applicable closing documents have been recorded in the county recorder's office. So the transaction is not actually complete, as all of you know, until the contract, or until the documents are recorded. And the lender has 4 calendar days after settlement to complete the funding. So we oftentimes run into hiccups where the lender will come up with additional funding conditions, or they run a final credit check as part of their due diligence, and they see that the borrower went to R.C. William, bought a bunch of furniture. So that delays the closing, but they do have 4 calendar days to resolve all that, to get that completed. So a lot of people think that it's automatic, that it's going to happen the next day. It's not always that way. They sometimes have some delays. Okay, 4.2, I love this part. I was actually, as president of the Utah Land Title Association, I was actually part of creating this part of it in the HOA assessments and dues and transfer fees, just because we were negotiating those at the closing table, and all of the, not all, but a lot of the management companies for the HOAs would say it's the buyer's responsibility to pay. Not necessarily true, because the buyer had no contractual obligation whatsoever to pay a transfer fee. They're not, the homeowners association can't just automatically levy that on them. So at the closing table, we were oftentimes, especially like in Daybreak and things like that, where the transfer fees are expensive, we were oftentimes negotiating that at the closing table, and that it was just a pain for the real estate agents, for the title companies, and the buyers and sellers. So now it's all spelled out for us. Any assessments for capital improvements under 4.2 as approved by the homeowners association or assessed by a municipality prior to the settlement deadline shall be paid for by, and so now it's all negotiable between seller, buyer, everybody negotiates that up front now. So if you're representing the buyer, obviously you want a check will be paid by the seller. So, and then, you know, we'll see if they counter that or not, but if you're representing the buyer, we want the seller to pay those. And then the other part of that is you can have it even split equally between the parties. So it really makes it easy to negotiate up front. Then section 4.3, rental deposits, 4.3b, rental deposits and security deposits or prepaid deposits. Really important if we know that there's a tenant in the property or there's any leases of any kind, we need to know that up front, because we'll have to get copies of those leases, because the security deposits will have to be debited from the seller and credited to the buyer at the time of closing. And then we'll have to know when the tenant's due date is on the lease so that we can prorate those rents for the month. So if you know that there's a tenant in a property, then make sure you communicate that with your escrow officer as soon as you can so that we can get all of that information, get a copy of the lease and all that fun stuff. Okay, and then on the HOA and other entity dues and ownerships, again, this is any transfer fees, anything like that that show up are going to be negotiated right now. And so like I said, if you're representing the buyer, same thing, you're gonna want a check paid by the seller. And then see whether or not the seller counters that back. But it gives us the opportunity to negotiate it up front so that we're not sitting at the closing table trying to figure it out. So that's a really, really good thing that they built into this new contract. And that is going to be our second keyword today is HOA dues. So if you guys want to take a second, write that down. Okay, again, that second keyword is HOA dues. Okay, and then I'm going to skip down to section 6. Oh, you know what? I didn't. There we go. Okay, section 6 on the title and title insurance. This is important as well. It says that the property shall be conveyed to the buyer by a general warranty deed. So the contract automatically requires the seller to deliver a warranty deed to the buyer. So we can't use quitclaim deeds or anything else unless that's negotiated and we have an addendum saying that we're going to do so. Oh, and I got a question here. The first keyword, sorry about that, was solar panels. First keyword was solar panels. Okay, then we're going to go to the next page under section 6.2. This is also something where in the split closing world, I see people making mistakes and not communicating things correctly. It requires, section 6.2 requires that the seller deliver to the buyer an ALTA homeowner's policy of title insurance or an EGLE policy of title insurance. That's really important to note because on some properties that is not going to be available. Oh, Allison, okay, the second keyword is HOA dues. HOA dues is the second keyword. Sorry, it sounds like it might be cutting out a little bit, so I apologize for that. But anyway, back to the ALTA homeowner's policy of title insurance. If the property has a meets and bounds description, or if it's any type of complex issue with possibly some boundary line conflicts or things like that, the underwriter is not going to allow the title company to issue a homeowner's policy. They're going to require that they issue a standard owner's policy of title insurance. So that is something that you want to watch for when you're representing your buyer. When you get that title report, make sure it's a homeowner's policy. If it's not, the title company should disclose that to you and say, hey, we can't issue a homeowner's policy on this particular property. But I see it time and time again where they don't disclose that. So make sure that you're looking at that when you get your commitment for title insurance. Make sure that it is for a homeowner's policy. If it's not, then you need to talk with your title company and your buyer to see how to resolve that. Maybe they want to get an extended owner's policy, pay for a survey, things of that nature. So that can all be negotiated, but I oftentimes see where the title companies just don't even tell anybody that it is a standard policy. So if the homeowner's policy is not available, it says that the standard policy can be issued, but that should be communicated to the buyer because the buyer's automatically going to think that they're getting the homeowner's policy. Okay, number 7, the seller disclosures. Something to keep in mind here is that a lot of what we do as a title company is part of those seller disclosures. 7C is a commitment for title insurance. 7D is a copy of the restrictive covenants. So those should be delivered to you to give to your buyer to make sure that they've received those and they've reviewed them prior to that seller disclosure deadline. So I always recommend to everybody, give 4 or 5 days on those seller disclosures. I see a lot of times where people put 24 hours because they've already got their sellers, have already filled out their seller disclosure portion and everything. But there is additional information that needs to come from us. And on some of these searches, like some of the complex meets and bounds searches and everything, those can take a couple of days to get done. So just so that you're not going out of contract, I would suggest give 4 or 5 days on your seller disclosures to make sure that that all gets done. I've actually got a situation going on right now on a split closing where the buyer wants to get out of the contract. And actually, they lost their job because of COVID, and they were trying to get out of the contract, and the seller's like, no, you're past all your due diligence. We are keeping the earnest money is coming to us. And so the buyer's got an attorney, and the attorney got reviewing everything and said, oh, the commitment for title insurance wasn't delivered until 8 days after the seller disclosure deadline. So the seller's in breach of contract. So now there's a huge fight going on over $1,000 earnest money. So that's the time and effort that takes to resolve is difficult. So if you don't have your title report, hopefully your title company communicates that to you and says, hey, we see your seller disclosure deadline is the Thursday. Sorry, we're not going to be able to get that PR out until maybe Monday. So hopefully they're communicating with you on that, but it is something that you want to pay attention to because it will put the seller in a difficult situation if that commitment and the restrictions are not delivered timely. Okay, and then also something else we talked about already is 7F, is any tenant leases or rental agreements. We need to get those from the seller as soon as we can to make sure that we don't have any problems with that. And then number 7I is evidence of any water rights or water shares. So we need to make sure we communicate that again and get that information. Okay. All right, section 8.3, the financing conditions and everything, that's pretty self-explanatory, but I want to go to 8.3BI, which is the borrower's right to cancel before the financing deadline. It also says that the buyer can deposit additional earnest money, or they can, so much of the buyer's earnest money shall be released to seller without the requirement of further written instruction from buyer, and the remainder of buyer's earnest money deposit shall be released to the buyer without further written authorization. Okay, that is assumed again that under paragraph 1, the first thing we talked about was the escrow deposit is with the buyer's brokerage. If this is with the title company, that doesn't work. That paragraph won't work because we're in a fiduciary position to where we can't release the money to any party without written instruction from both. Once it comes here, we've got to have written instruction from both parties to release earnest money. So that portion of it, we oftentimes have agents say, well, it says that, and I'm like, yes, but that's if it's held by the buyer's brokerage under paragraph 1 of the REPC. If it's held by us, we're held to a different standard and different guidelines in which we can't release it. So really important to know that. If the REPC is canceled under III, the buyer agrees that all the buyer's earnest money shall be released to seller without the requirement of further written authorization. Again, that is assuming that the earnest money is held by the buyer's brokerage. Okay, additional earnest money deposits. The buyer can make additional earnest money deposits if they want to. Sometimes that might strengthen an offer maybe, especially in this competitive marketplace. That might make an offer a little more desirable to a seller if there's going to be some additional earnest money put up. Okay, number 10 is the home warranty. Pretty self-explanatory there. It says whether or not there will be a home warranty and who's going to pay for it. Seems like title companies are ordering those home warranties more and more, and so just important to note that when that happens, just kind of communicate with your escrow officer on whether or not you're going to have them order the home warranty. Okay, number 13 on the next page, the authority of signers. This is really important, you guys. If you go out on a listing appointment and somebody says their property's in an LLC or it's in a corporation or a trust, anything like that, we're going to need additional documentation to make sure we find out who the actual parties are who can execute the documents, to make sure that you have valid contracts and then that we have valid deeds and everything at the time of closing. So the sooner we can get the corporate resolution or the corporate documents on the trust or LLC, the better. The trust, oftentimes people don't want to release the trust to us because it's got a lot of personal information. Some of them are very lengthy. So we can talk with the seller and just let them know what we need, which is the declaration page. We need to know who the trustees are and who the successor trustees are and what the powers and authorities of the trustees are. So we can work with the seller if they're not wanting to give us the whole trust, that there are things we can do to work through that. Okay, number 19 is important to note, no assignment. So the REPC cannot be assigned without prior written consent of the seller. So in this, where we've got such a great market right now, this 2006, 2007 thing is coming back where people are putting properties under contract and then trying to assign them. And then they tell us, well, don't show the assignment on the settlement statements. We don't want the seller to know. And it's like, well, it doesn't work. We can't do that because the contract requires written consent from the seller before you assign the contract. So very important to note that that cannot be assigned. 21, time is of the essence. Performance under section Rep C, which references a date, shall be absolutely required by 5:00 p.m. So we've had situations where the lender doesn't get documents to us by the settlement deadline until like 7, and then we close at 8 or 9 at night, and everybody's going, well, don't tell the seller, and I have no problem with that, but if anybody asks, we would have to absolutely let them know that it did not happen by 5 p.m. So it's not necessarily something we have to go out and tell them, but if somebody does ask, we would have to be forthright on that. Okay, and then the next page is the contract deadlines under paragraph 24. Again, just a piece of advice is give enough time on those seller disclosures to make sure that your title company is getting the PR to you and the restrictive covenants in a timely fashion. So make sure that's happening. Okay, this is a form that the Division of Real Estate came up with. for the earnest money to be deposited with the title company. So as I mentioned before, the earnest money under the contract itself says it's going to the buyer's brokerage. So if it's going to a title company, the Division of Real Estate has come up with an addendum that allows it to go to the title company. So it says that the buyer and seller agree that that money is going to the title company in the trust account. And that's important to note too, because if the seller doesn't know that the money is going to a title company, that could cause you problems down the road if it's not what the buyer's brokerage is required under the contract. So really important to make sure you use this addendum if you're going to deposit the money with the title company. Okay, and then the title insurance company, it says attention in bold. The title insurance company may require through separate written instructions both buyer and seller mutually authorize any disbursement. That again goes back to what I was talking about once that money comes into our account, into our trust basically, then we become a fiduciary for all parties, and we cannot follow just one party's instruction, and we can't follow any previous instruction that was before that we received the money. So we would have to get approval from both buyer and seller to release that. So, and then in the event of a conflict, all prior addendums, these terms shall control. So again, make sure the buyer and seller know that it's going to the title company if you're going to do that. Okay, here is a little thing from Curtis Bullock. The agents have been fined up to $500. I've seen it happen several times now. Agents are fined $500 if they don't disclose to the seller that the earnest money is going to a title company. So again, the seller assumes that earnest money is going to the buyer's brokerage. So if it goes somewhere else and there's nothing in writing, the agents are getting fined $500. So be careful on that. Make sure you got yourselves covered, because I'd hate to see anybody have a fine like that. Then the next document is from an attorney regarding earnest money, and just explaining again why a title company cannot release that money once we receive it without written instruction from both parties. So just to make sure that it's just a good piece of reading if you have time to read that. Okay, and then here's a bulletin from the insurance department. Title insurance producers, this I want to go over. Title insurance producers at the bottom that agree to conduct escrow should use detailed written escrow instructions that clearly and unambiguously describe the terms upon which funds are held and dispersed. The Utah Land Title Association, on the second page, has created 2 forms to be used as an escrow agreement. So, and those forms I've attached for you in the event you don't want to use the division form. We've got joint escrow instructions regarding the earnest money that the buyer and seller can use if you don't want to use that addendum. And then we've got the release of earnest money so that we can release that money after, if someone's either defaulted or the buyer's due diligence has expired or the buyer cancels the contract within their due diligence period. We just send this release out, get it signed by both parties, and forward the money. So it gives us specific instruction on what to do. Okay, next one's just a simple addendum. You guys are familiar with this and how that works, so there's really nothing to mention on that. Okay, the FHA VA loan addendum requires that the seller can make certain repairs and they shall furnish pest control reports, things of that nature. Also on the closing costs, I suggest that you communicate real closely with your lender on those closing costs that the seller is going to be contributing, because we oftentimes have, if there's an overage, it says seller will pay up to $4,000 and it only comes up to $3,200, then we're asked on our end to do something outside of the closing with that other $800. We cannot do that. That's a breach of the escrow instructions from the lender and can get us in a lot of hot water. So like refrigerator, do a bill of sale for refrigerators, things like that, we can't really do. So just communicate with your lender and make sure that you've got those closing costs as close as possible to make sure there's no money left on the table. And then, yep, I covered that, so. Okay, now is a real estate purchase for land. Again, the very first paragraph says that the earnest money is going to the buyer's brokerage. Then under section 1, the property, if this is for land or a lot, if you can include a lot number or a tax ID number, that would be fantastic, because a lot of times on vacant land, the addresses are not shown yet in the county recorder's office. So we have a hard time sometimes finding it just by an address. So if you can get a lot number or a tax ID number, that is very, very helpful when you're dealing with your seller. So helps us get everything done on our end. Okay, 3.3. This is really huge, you guys, on the greenbelt taxes. If the property is farmland or assessed as farmland, and you've got your title report, and we've got that exception in there, the greenbelt the county can go back 5 years and reassess that property at full market value. So that can be, I've seen them as high as $150,000 for property taxes. So make sure when you're negotiating on behalf of your buyer that you're checking that the seller will pay that, because it's really the seller's obligation to pay. But it is, again, they've got it here to where you can negotiate it up front between seller, buyer, or split equally. But the seller is the one that received that tax benefit for all those years. So really, they should pay it, but it is negotiable. So just make sure that if you see that there's green belts, or if you assume there might be green belts, that you address that right there. The special assessments, something else that it's not actually built into the contract, but something that you would want to talk to your buyers about doing some additional due diligence on, are connection fees and impact fees. So they might buy a lot and think, oh boy, now I'm just going to go get my building permit. But in Summit County and places like City Creek Canyon, the impact fees are huge. So when they apply for a building permit, they pay a big impact fee for schooling, things like that. So I suggest on the special assessments under 3.4, the buyer do some additional due diligence with the city to make sure that they're not going to be hit with any big problems or big fees or assessments when they apply for that building permit. Okay, number 6.2 requires that the title company issue a standard coverage owner's policy. So on this particular form, we're issuing a standard policy, not a homeowner's policy, because it's vacant land and there's no improvements. Okay, the seller disclosures again require the commitment for title insurance and the copy of the restrictive covenants. Okay, under H, the impact fees again when they apply for a building permit under H, so they can put that there. Okay, nothing on that page. Okay, again, this contract, number 19, says no assignment. So again, this contract cannot be assigned, so somebody can't buy the lot at this price and assign it to someone else without the written approval of the seller. So we've got to keep that in mind. Okay, and then the contract deadlines, again, the seller disclosures. If you can give enough time there, that's great. Okay, the next one is a bulletin from the Department of Insurance. Oftentimes we're asked to hold money for a lot reservation for the plat has not been recorded yet, but the developer is taking reservations for the lots and they want us to hold that money. We cannot hold that money because there is no contract in place and no title insurance policy being issued at that time. So we can't really hold the money until the lot's recorded and it's an earnest money deposit. So lot reservations we're not allowed to hold. Okay, then on the new construction real estate purchase contract, there's really not a lot to go over on this because as most of you know, when you're dealing with a builder and new construction, they normally have their own form of contract these days. They don't, you don't usually use your own form. We have to use the builder's form, so there's not a whole lot to go over on that one. But again, if you can identify with a tax ID number or a lot number under section 1.1, that's always helpful. Okay, construction deposits under B on this page. Those are non-refundable. Always remember that. So if your buyer's putting down a lot of money on a construction deposit, that's non-refundable. Special assessments, again, are negotiated under 3.3 between buyer and seller. Okay, title to the property is to be delivered by a general warranty deed, same as on a the regular REPC. Title, and one thing we need to be aware of is mechanics liens, and builders require standard coverage policies. Most of them won't pay for a homeowner's policy. So really important to note when you're looking at that REPC, like I said, they don't use the state forms very often. They have their own forms, but I recommend looking to see what type of title policy they're offering to your buyer. And if they're only offering a standard owner's policy, I would recommend that you have your buyer pay the difference to get a homeowner's insurance policy that will cover against mechanics liens. Those of us who have been in the business a long time remember the problems from 2008 to 2014. Mechanics liens were brutal, and these poor buyers, you know, they go in and they pay a contract in full, they think everything's fine, and then all these mechanics liens show up. They try to make a claim on their title policy, but they only got a standard coverage policy that does not cover against mechanics liens. So it's really, I know business has been really good the last few years and everything, but if things turn and these builders stop paying their subs and there's mechanics liens that come up for your buyers, that's a huge problem. So make sure you're checking that contract to see what type of policy they're getting, and at least discuss the option with your buyer about getting a homeowner's policy to protect them against mechanics liens. Okay, and see, that's about it there on that page. Okay, number 8.2a. Oftentimes, and that's the construction loan, oftentimes the builder will require the buyer to go get their own construction loan. One thing that I would always recommend is make sure that the buyer approves all disbursements. Again, that's to protect them against mechanics liens that could arise later. We don't want to give the builder authority to make all of his own draws without the approval of the buyer. So we want to work with the mortgage lender, the construction lender, to make sure that the buyer approves any and all draws for payment to subs and materials. Okay. Nothing there. Okay, again, on paragraph 20, this contract is not assignable without the approval of the seller. So all of the state forms are pretty much that way. Okay, now we've got a commercial real estate purchase contract. Now it's funny, on this one, in the very first paragraph, it says, the earnest money shall be deposited with the buyer's or delivered to the buyer's brokerage or the title escrow company. So I find it interesting that on the residential stuff, it all requires it to go to the buyer's brokerage, but on a commercial deal, they give you the option to go to the buyer's title company. So just kind of interesting there. Okay, and then on the commercial contract, thing I wanted to point out to you is on 6C, if you're representing the seller and the buyer put on there that they want an extended owner's policy, just be aware that to issue an extended owner's policy, we're going to have a survey. So there are additional costs and expenses there that are going to be negotiated between buyer and seller. So if you're representing your seller and the buyer has checked that the seller will pay for it for an extended policy, you may want to counter that in an addendum and just say, no, if you want an extended policy, you can pay for it. So because like I said, there is going to be a survey and everything else that's going to have to go along with that. So important to remember that. There. Okay, and then on this one, another thing that's different on the commercial is paragraph 14 says this contract shall or shall not be assignable by the buyer. So this gives the option on the commercial contract for the buyer to assign it. So just, I find that it's like the commercial contract is much more flexible than the residential contract as far as earnest money and assignability and everything else. Okay, now we've got an assumption addendum. Most people have never done an assumption. I've done a lot of them back in the 1990s, late 1980s. So I've seen them. If interest rates jump up to 7 or 8% again, or even 6 or 7%, we may see some of these. So this is an assumption addendum to where the buyer can request to qualify for the seller's existing loan. So let's say the market kind of goes bad again and everything, and the seller only has 10,000 in equity and the buyer wants to cash out their 10,000 and take over their existing loan, then this is the form that would be used. Okay, and then the assumption fees charged by the lender is negotiable as far as who's going to pay for what. The release of liability is really, really important. If your seller is being released of liability, then we need to get that from the lender and make sure the lender puts that in writing, that the seller is released of their obligation under the note and trust deed. And we'll receive an actual assumption package from the lender that will give us specific instructions on how that's going to work. Then the difference in the loan balance needs to be paid in cash or other, however the buyer's coming up with that. And it's important to note here that the reserve account is held by the lender, has to be purchased by the buyer. So the buyer needs to purchase that from the seller on an assumption. Okay, the seller financing addendum. There's a lot of seller financing going on right now. I don't know why, but there's an awful lot of it. So really important on this, you guys, if you're doing seller financing, make sure you're working with a seasoned pro on the escrow side that knows what they're doing and how to prepare the documents, because you know this for the buyer and seller can be huge. And I'm going to point out some of the pitfalls and things that can happen here. Okay, the paragraph 1 says that the seller financing will be either a note and deed of trust or a note and all-inclusive deed of trust. So let me tell you the difference there. The note and deed of trust would be if the seller owned the property free and clear, okay? Or if the seller was going to take a second or something like that, then we would use the note and deed of trust. If there's an existing loan on the property, that, so to speak, we use the all-inclusive note and trust deed. So important to note there which documents you're going to be using, if the seller owns it free and clear, or if there's an existing loan that we're going to wrap with a new financing from the seller. Okay, and then it says other. There's really no other way to sell real property except under a uniform real estate contract or sometimes a lease option, things of that nature. So you can actually discuss that there. Okay, on the credit terms, I always recommend that the first payment is due 30 days from the date of settlement, because if it's not, we can run into problems. Like if we're closing on the 28th and then the payment's due on the 1st, we can run into some problems there. By the time we get it to the escrow company or whoever's handling it to make the disbursements, we could potentially cause the seller to run into a late fee. So, and we don't ever want to do that. So I always recommend put it 30 days out, and then we can collect from the seller that payment at the closing. And then that gives the escrow servicing company 30 days to get all of their documentation set up and everything so that we don't have any hiccups and the seller doesn't have any dings on their credit. Balloon payments are a big deal. Any additional principal payments or balloon payments or any other items are as follows. If the underlying payments we need to prorate that interest. Like if we were closing, like I said, on the 28th to the 1st, we would have to prorate the interest on that underlying loan from the 28th to the 1st. The escrow accounts, again, need to be purchased by the buyer. So because the seller's got escrow accounts sitting there, if this is an all-inclusive, the buyer's going to have to purchase that escrow account going forward. And then be careful. I always recommend we get a copy of the underlying note, and we want to make sure that there's no balloon payments or adjustable rates. If the seller's underlying loan is 5% and our buyer is buying it at 6% to make the seller a little bit of money, but there's a balloon payment or it's an adjustable rate and it bumps to 7.5, that can cause the buyer a lot of grief. So make sure we get a copy of those notes and we know what's underneath there. Balloon payments can also be a big thing. If the seller's got a balloon payment in 3 years, but he's agreed to finance it for 5, that's going to be a problem. Okay, the taxes and assessments is paid directly to the seller or directly to the applicable county treasurer. That would be if we're using a note and trust deed. If we're using an all-inclusive, it's probably going to go to an escrow agent. So if you're going, and even if the property is free and clear, I do recommend an escrow agent. We use escrow specialists. They've been around for a long, long time. They really know what they're doing. And the problem with the payments going directly to the seller is they're not going to get their, for the interest that they paid for the year and everything else. The escrow company will take care of that for the buyer and the seller for reporting to the IRS so that the buyer can write off that interest. So I always recommend an escrow company, even if it's not, even if there's not an underlying loan. Okay, late payments and prepayment penalties. Under paragraph 5, any payment not made within however many days after it is due is subject to a late charge of blank or blank. Okay, this is really, really important, you guys. I've seen where it says that any payment not made, and yet on seller financing, there's usually a balloon. Most sellers aren't going to do 30-year financing. Most of them are going to want their money back in 3 years or 5 years, whatever that may be. We had a situation years ago where the buyer was trying to refinance to pay the seller off for the balloon payment, and they went past the date, and so there was a late fee. Well, the seller was saying that, no, you owe me, the late fee was 5% of the installment due. The seller said, well, you owe me 5% of $300,000. So, because it was a balloon payment and the contract says any payment due. So I always recommend under paragraph 2, under the credit terms, that we address paragraph 5 and state that if you're representing the buyer, you want to state in there that the late penalties described in paragraph 5 apply only to the monthly payments and not to the final balloon payment. Just so that that's clear to everybody going forward, because I mean, if the buyer's doing their due diligence, but there's a glitch with their new loan for the refinance and everything, and the seller hits them with that, that's something we never want to see happen. So, okay, and let's see. The seller may require, under paragraph 8, the seller may require the buyer to provide current credit reports, financial information, bank statements, etc. The seller has the right to review that. Title insurance, this is negotiable. It says the buyer shall or shall not provide the seller a lender's policy of title insurance. I'm in the business of title insurance, selling title insurance policies. That's how I make my living. But in all honesty, I don't think that that is necessary in most cases, unless the seller is adamant that he get it, because there's already an owner's policy being issued to the buyer. So they don't really need to provide that seller with an additional loan policy. I mean, but like I said, sometimes that's the only way the seller will do seller financing, is if the, okay. Just a quick note, at Presidio, all seller financing needs to be approved and or be reviewed by Brian Crawley. So just so that you all know that. And that's a great thing to have, because like I said, if mistakes on this addendum can cost thousands and thousands of dollars to your buyers and sellers. So we want to make sure those are correct. Okay, so that's it on the seller financing. Short sale addendum. Thank goodness we're not doing any of these right now. Those were tough. But this is the short sale addendum. If you're doing a short sale, this just tells all parties that it is subject to a third-party approval. So the seller and the buyer both know that they've got to have approval from that lender before we can have a closing. So other than that, there's not a lot to go over on that until we get back into short sales. Okay, this is a bulletin issued by the Department of Insurance that I'd like to make sure everybody's aware of. A lot of title companies were negotiating those short sales for the real estate agents. That is not allowed under the Department of Insurance guidelines. Title agencies are not licensed to negotiate contracts, and so they are not allowed in any part of the negotiation, and it just says the negotiation of a short sale transaction is prohibited. So just important to note that the title companies are not licensed to negotiate a contract, and they cannot negotiate the short sale. Okay, and then this goes with that. This is just the acknowledgement of the third-party approval, so that once you get that approval under the short sale, then all the dates start to kick in as far as our closing dates and everything else. So once we've got that third-party approval from the lender allowing the short sale, then this is the addendum that we use to set the final dates. Okay, this is an assignment and assumption agreement. Okay. Of the purchase contract for new construction. So this allows for buyer one to sell to buyer two. The assignment fee must be shown on the settlement statements. So if they're assigning the contract to another buyer for $10,000, that $10,000 assignment fee needs to be shown on the settlement statement to make sure that the seller understands that. And then if they're going to assign it, you can apply brokerage fees to that assignment, which is really nice. So if you're representing the parties, you need to be able to do that. If buyer number one doesn't own the property, they understand that, they're going to have to enter into a separate contract. And delivery of additional documents, buyer's right to cancel. Okay. Okay, and then we've got the owner's developer's consent to the assignment. So they've got to, this is page 6 of 6. So again, it can be assigned, but the seller or the owner or the developer has to agree to the assignment. Okay, and that's just the same. This is a simultaneous closing addendum. So if you are doing an assignment, or let me rephrase that, you're not doing an assignment, and buyer number one has already entered into a new contract with buyer number two, this just tells everybody what's going on there. Tells them that buyer number one does not own the property under paragraph 1.1. Paragraph 3.1 says buyer number two acknowledges buyer's number one's obligation under the second REPC and are conditioned upon buyer number one completing the purchase under their contract. So that's important because that protects buyer number one if, in fact, they aren't able to perform, or for whatever reason that first contract doesn't close, then that says that the buyer number two already knows that and acknowledges that that contract has to close before the second contract kicks in. Okay, let's see, nothing there. And again, there's brokerage fees under paragraph 7, which is good for you guys. Okay, and then this is a bulletin from the Department of Insurance that just states that we cannot, oftentimes if we've got that simultaneous closing, people will want us to close the first deal and not issue title insurance and just collect the deal from buyer C. So A to B, B to C, buyer B has to perform under his contract or his or her contract before they can move on to the second contract. So whether they do seller financing or whatever it is, they could do seller financing for 10 days or whatever it is, that first contract has to stand on its own before the second contract can close. So we cannot skip from A to C and use C's money to complete B's purchase. That is an illegal flip or a prohibited escrow from the Department of Insurance. And they've got just a little diagram here that shows that. So A to B closes, B to C closes, there's nothing wrong with that. But the illegal flip or equity skimming is when, on the bottom portion, when A sells to B, B sells to C, and we use C's money to complete B's transaction. Cannot do that. And we still get asked to do that quite often, but can't be done. Okay, lease with option to purchase. I recommend with this, you always talk to your broker. If you're entering into a lease with option to purchase, these can be very scary in the event that the buyer is putting down a substantial amount of money up front. And if the buyer is paying an amount of money that part of that monthly payment is going towards that final purchase price, then this can really cause some problems. There hasn't been any case law yet, but there's been several lawsuits filed, and the attorneys that I've talked to have said that if they are putting a substantial down payment, and if they are making monthly payments where part of that is applied to the contract, they consider it to be like a uniform real estate contract, where under the doctrine of equitable conversion, the seller just has naked title and the buyer would have equitable title. So I always recommend check with your broker. And I also would recommend that if you're doing one of these, you get something signed by your buyer that states that you've counseled them to seek an attorney and they've declined or accepted to do so, because this document can cause a lot of grief. So, and then when the foreclosure process in that is just, so they would have to, rather than foreclose like on a trust deed, they have to go and do what we call a non-judicial foreclosure, or a judicial foreclosure, where they have to go through the sheriff's office, do the sale, takes 180 days, and then after the sale, the seller would get just a certificate, and then the buyer has a 180-day redemption period after that. So by the time the seller goes and sues for a judgment, forecloses his judgment, and gets the buyer out of the property, could take 3 years. So really important to make sure that you're covering your butts on that. Okay. Yeah. Okay. One thing I wanted to mention on the seller financing addendum that I forgot to mention was on the due on sale clause. There is, the contract requires a due on sale clause that says if the buyer sells or transfers any portion of the property, that the seller can call the note immediately due and payable. So that is our third keyword today, is due on sale. So go ahead and write that down. Due on sale is our third keyword. Okay. And then this is an addendum to the lease option. Just when the buyer gets ready to close, or any additional terms can be added to this. I always recommend use the board forms. Never use an addendum to negotiate a lease option. These forms protect all the parties. I see it all the time where somebody just does an addendum that says buyer's going to do a lease option, deposit X amount of money. Don't do that. Use these board forms and make sure that you're covering your butts and the buyers and sellers. And then the notice of intent, once the buyer gets ready to purchase, they send the notice of intent to the seller to let them know that they're going to be purchasing or exercising their option to purchase that property. Okay, then something a lot of real estate agents don't know is that we can actually do closings for mobile homes and things of that nature, which is good because it gives another party, puts another party in there to assist you. So anything we can engage in the escrow business and not issue a policy for mobile homes, grazing rights, or water rights. So just so that you know, if you run into one of those mobile homes, oftentimes people don't realize that the title company can help on that. So we're happy to help you with those if you run into that. Okay, and then we have a agreement to sell. So if you're actually working with one, we have an agreement to sell the mobile home because it's not, you can't really use the REPC because it's personal property, not real property. So we have an agreement that we will share with you if you need to use it, if you've got one. Does anyone know, is there a board form? Does the Board of Realtors have a form for mobile homes, or does anyone know the answer to that? No? Okay. So yeah, feel free to call us if you've got a mobile home. Feel free to give us a call, and we're happy to provide this contract to you so that you can use that. Okay, and then we have our mobile home closing instructions. Seller must provide a closing, any payoff information. So again, this just says, and this is important, the legal counsel disclaimer. We want to make sure that us as the title company and you as a real estate agent know that the buyer and seller have had the opportunity to obtain legal counsel. It just tells everybody that the mobile home is personal property. And so what we do is, if it's free and clear, we require the seller to bring that title in, just like title to a car, and bring that title in and transfer it over to the buyer at the time of closing. If there's a loan on it, then we will handle the payoff on the loan and give the payoff lender all of the buyer's information. So, and a copy of a bill of sale. Okay, I'm going to go over all those general conditions. Okay, this is an affidavit of a fixture. Oftentimes, we've got a mobile home that has been affixed to the real property and is now on a foundation. And so it's real property, it's being taxed as real property, but the lender says, no, we can't make the loan because it's a mobile home. So this affidavit of a fixture can be used to record in the county recorder's office, and it just basically says that the home is permanently affixed and the buyer has surrendered the title, the personal property title to the county assessor. Okay, and then just detecting double contracts. We've talked a little bit about some of the flips and schemes and everything, but double contracts, we're not really seeing a lot of that right now with straw buyers and everything, but another thing that was happening a lot was what we call mortgage stacking, where somebody would be friends with somebody at a title company and ask them, hey, don't show that loan so I can get a new loan. And they put like 5 first mortgages on a piece of property, and fake cashier's checks were being used, asking escrow officers to tell lenders they received it, but not deposit it. Stated income, no doc loans. I'm glad we don't have, I hear they're coming back, but hopefully not. I think that's cleaned everything up a lot. The mortgage lenders with those stated income loans, it wasn't hard for people to falsify their income and everything else because they didn't do any checking. There was no due diligence. So really the mortgage lenders created part of that crash in 2008 to 2014 because of their own underwriting guidelines and the loan products that they had available. So at that time, mortgage fraud was really easy to do. At this point in time, it's a little more difficult because the lenders are doing a lot more due diligence. So just, you know, if it feels wrong, don't do it. I've got a lot of different scenarios there that you can read through regarding straw buyers and things like that if you guys would like to read this. And if anybody would like a copy of this presentation, just let Chantel know, and we're happy to forward it to you. Or do they already have it on the link?
I mean, they'll have the slides, but I can, off of the roster, I can just automatically forward the
Okay,
slides.
so yeah, any of you who would like a copy of this presentation, please feel free to let us know. And also, that brings us, you know what, that brings us to the very end. See, cooked through.
This is Yvonne. I have a couple of questions about a double contract.
Okay.
So I know some agents do not want to put their repairs on an addendum, and they negotiate that on the side, and that is a double contract.
Absolutely.
And I know that a lot of them in the past, I think they're better now, would do an escalation clause on the side. That is a double contract.
Absolutely. Absolutely. So those are the types of things that we...
If you don't mind, this is totally off the subject, but I had an agent in here that was really upset for her friend, which wasn't with us, and I didn't ask what agency she was with because I don't care.
Okay.
I cared that she got, it's to do with wire fraud. And so to make it really short and quick, when the money was wired from one company from her buyer, the one title company was insured because that money got hijacked to offshore accounts, and the other company said we do not have insurance to cover that, and the one said they did. So there's probably going to be some really big legal issues with that.
Yes.
I don't want to get into that, but I just want to know, how do we just ask, are you insured for title for fraud?
Yes, that's a good thing to ask. And integrated title is. We do have a cyber liability policy, and we have E&O. So we carry both. Some title companies don't. And a lot of the mortgage lenders now, as part of their due diligence in vetting title companies, are requiring them to have that cyber liability contract in there. But they got to be really careful because wire fraud is so prevalent right now that a lot of the insurance companies, even though they'll do the cyber liability, which protects you from somebody breaking into their system, they've now excluded the wire fraud, and you have to get a separate addendum for the wire fraud. So it's so, can't understand how in this day and age we can't figure out a way to catch these guys or somehow stop them. But it's terrible. It's ruining our industry. It really is. It's such a tough thing, and it's happening so often. We probably see 2 or 3 a week where somebody pretends to be our borrower or pretends to be the payoff lender or whatever that may be. So it's, we have certain policies and procedures in place where my escrow officers cannot make any changes based on an email. It just won't happen. We don't do it. We have to, and then I have them get the wiring instructions at the time of closing. One thing that you folks can do, and I do have a flyer I can send to you if you'd like, is at the time you do your listing presentation or when you sign your borrower or buyer's brokerage agreement, give them the wire fraud flyer and just let them know. Do not send money anywhere without talking to the title company personally. Here's their phone number. Do not call any other number. Do not send your money any place unless you've talked to these guys. So, and that's why we get the wire instructions from our sellers to go to their accounts at the time of closing. We collect it at closing while they're physically here at our table so that we can't run into that problem. So it's just scary. And these criminals are getting so smart. So it's really scary. Okay, and then that brings us to the 4th and last keyword, which is ITS title. So please keep us in mind. We'd love to be a part of your team and make sure your transactions go really smooth so you shine in the eyes of your buyers and sellers. And just give Chantel a shout and let her know if you've got any business you'd like to send our way, and she'll get you hooked up with one of our awesome escrow officers. Or you're welcome to reach out to me as well. Somebody was asking about number 2 again. That the keyword for number 2 is HOA dues. I know it was deleted. Where do we submit the keywords?
Okay, yeah, so I was just going to put out here again the link for everybody to get on for the roster and the keywords. So if you joined late, there's the link again. So go ahead and grab that. Everybody's got all 4 keywords I heard. For Linda, keyword number 4 was ITS title. Just so you have it.
I'm the bad girl. I missed number 3.
You missed number 3, due on sale.
Due on sale.
Yep, and Karen, I think, asked, so as long as you guys fill out the roster, I'll just email the slides out to everyone, and the roster will collect your email. So just make sure you get that filled out.
Yeah, get those filled out and back to Chantel as soon as you can.
Please
And then
leave the link on longer. The link should stay in the chat, Robin. I'll put it up one more time, but the link stays. Or did you mean on Yvonne's end as far as when we get off? I'm sorry. But there's the link again.
I will not end this because as soon as I end on my side, it cuts off the chat. So I will give you plenty of time to check the chat.
Okay.
And so she's like, Karen, I saw your note about wanting the wire fraud flyer, so I'll make sure you get that.
Yeah, actually, we'll send that with the slide program so that you all have it. And like I said, I really, when you're sitting down at your listing agreement, the best thing we can do is educate buyers and sellers that this is going on, so they don't send their money someplace they shouldn't. Well, I really appreciate all of you taking time to sit down and go through this today. Hopefully everybody learned a little something. Like I said, I know you guys are experts on the contract, but hopefully I gave you a perspective from the title side to help you guys avoid any pitfalls.
Well, thank you very much. We really appreciate it. We appreciate those that are here with Presidio, and we love those of you that have joined us from other brokerages. So anytime you're welcome to our classes. We teach Monday through Thursday and always at 10. And if you go to Presidio, UTAHRE.com, you can get a list of all of our classes there. If you click on the non-agent, it will take you right to the place where you can sign up for them. So welcome. We appreciate you. We feel like educated agents makes for a better realty community. So
absolutely.
Thank you for showing up, everybody. Thank you.
Thanks, guys.
Great.
Thank you all so much. Enjoy your Labor Day weekend. Hopefully everybody's going to do something fun.
I only passed 500 people headed out of town with their boats and their campers and their side-by-sides. I tell you, everybody's headed out.
Yep, that's about all you can do these days. It's great social distancing.
It is. Fun time in the fresh air.
Yeah, for sure.
Thank you.
Thanks, guys.
Watch for our classes. We'll have Chantel and Scott back again. Every time they teach, you want to be here.
Okay, thank you.
Before I sign off, any questions? Oh, I think they left. I used to do all of that, Judy.
What happened now?
Hey, there's Brandon. I didn't see you. You must have just peeked in on the end, huh?
I was back and forth, in and out. I had people in my office, so I had to get off, and so.
Well, it's good to see you. Oh, Brandon, when have you scheduled your test?
Somewhere in September.
You know, everybody, I'm your cheerleader. So Brandon is, actually, I think he's ready to take his broker's license test. And so I have to cheer him on, right?
I'm right there. I just have to schedule it. I know we've talked about it a number of times, but my time will free up here in about a week, so I'll be able to do it.
What
Well,
office
Brandon,
you will be?
He's with
I'll still be
ours.
right there. I'll still be right here.
There
Yeah.
is a very nice office I like you to join in South Jordan.
No. We're not giving him up. He's ours. He lives in Heber City, by the way.
So we can open the another branch in Heber City. I work in Daniel.
There you go. There you go.
That's kind of what I told him too, other than I adore Brandon ever since I learned to recognize him.
You're gonna make me move to that area, I guess.
It's
Well,
beautiful
I
up
appreciate it,
there.
guys. It
Yeah,
sure
it's
is.
So
good.
have you guys got everything out of the chat you need?
Yes.
Well, I don't. I've been yakking, so I'm gonna go find it. And thank you very much. See you Monday for Presidio Champions.
Yes.
Are we doing that on Labor Day? Or is
Oh, you know what?
everyone's off?
Oh my gosh, no, I think our office is closed Monday. Don't show up. So if you need anything from your office, like signs, key boxes, lock boxes, be sure and get it ahead of time because they want a weekend too, okay?
Okay.
Well, happy Labor Day.
You
Take
too,
care.
same. And enjoy barbecue.
Thank you. You guys are the best, you know that.
Yes, we do.
Well, you better, because I'm your cheerleader.
Okay, where is
Tiffany,
your
Linda, it was good to have you. I'm gonna take a picture of this so I can.
close my face close to you?
You know what? Oh, Jesse, I like your face framing my picture.
You should see my Indian outfit then.
Well, are you wearing that Tuesday? Oh, look. Look at that guy. Oh.
Thank you. Thank you all. I enjoyed it. I will join you again.
So who are you? Are you Linda or Tiffany?
I'm Linda.
Linda, welcome.
Yes.
Please
Yes.
do. We
I
love
have
having you.
I have 26 years in the business and recently left Coldwell Banker after 26 years. And so I am now at Better Homes and Gardens, and I will spread the word with your classes. Without being able to have CE classes, this has been a real adventure and treat. Thank you kindly.
Linda, I wish you were here. I will tell you that they contacted me, Better Homes and Garden, and asked for my training. And I said, you're welcome to sign up, just like all of our other agents that are not with Presidio.
Uh-huh.
So I'm just jealous that you should be here. This is where the training's at. But
don't know,
I
with
promise to love
26
you anyway, okay?
26 years, it is a nice review, but I've closed over 900 products or properties, and so I've got a good client base, and I'll join you again. Thank you so much. It's been impressive.
Oh, Linda, I started out at Coldwell Banker in Logan, so I know that it's hard to switch, but
It is.
you're welcome back anytime. Tiffany,
All right.
welcome back.
Thank you kindly. Bye now.
Bye-bye.
So we are over, done.
Jesse, I think it's just you and I, Guy. So
I
I'm
know.
going to end this.
Okay. Bye-bye.
Bye.
Have a good weekend.
You too.